Nusrat sir, you are still not audible. You have not tapped on the mic on the left bottom of your screen. Okay. While sir is figuring out his tech, I'll just introduce everyone. I'll introduce the everyone ko kaise? I'll introduce the session to everyone. Okay. So the speaker that we have, you've already seen Nusrat sir, a very graceful young man. Young because I'm purposely saying young. He's been practicing for 40 years now. He's a professor for 40 years in the GLC Law College in Mumbai. It's a very famous institution for law and many other disciplines. And young because I very recently got to know that Sir plays tennis every day. He chills at his farmhouse once or twice in a week, and he also bunks his court proceedings sometimes to go there and play tennis and have fun and chill. So that's a motivation for everyone. He's a young at heart person and always smiling, always very happy, always a pleasure to talk to every time, all the time, and an institution in himself. He knows everything about everything, literally. You ask him limitation, specifically CRPC, CPC, he knows everything, and with the very specific provisions also. So that's the kind of person that we're going to interact with today. The agenda for today is that we're going to cover the entire specific relief act, not in depth, because that is what we're going to do in the course that is going to come on LCI's platform on 7th October. We're going to start with a course which is going to be in depth, around 20 classes of specific relief act, जिसमें हम लोग judgments, practice, drafting, whatever comes and goes out of specific relief act in courts, in theory, everything. That's what we're going to cover. And if you guys are interested in taking on those classes, this is my phone number on screen, 7536006300. You can send a hi and I'll send you the link to enroll. And that's going to start from 7th October if I've not already mentioned that. Okay. Nusrat sir, still not audible. We can see you up close, but you're not audible. Okay. Also, this session might take longer than 8:30 to 9:30, which was stipulated in the campaign. So it might be 10:30 as well, because sir tends to sir flow में आ जाते हैं. Sir, still not audible. Sir, I'm sending you a request. You'll see on your screen to just tap on unmute there. Yeah, check out now. Check out now.
हो गया. Is it okay?
Yes, yes, very okay. We can hear
because I don't know to handle it. Let me remain as it is.
Yeah, no problem.
Problem आएगा मुझे.
कोई बात नहीं sir. Okay, so I've already introduced sir to everyone. I've introduced the agenda also. And everything else that I had to, and I've introduced my phone number also. All those who would want to join the course can catch me up on this number. ये हुई हमारी campaigning and marketing, and now we can start with the lecture. Over to you, sir.
Yes. We will start the Janam Patri of this specific relief act. Janam Patri, kahan paida hua? The earliest act was of the year 1879, which was the early legislation based on the English common law principles. Please note that 1879 Then उससे पहले 1862 में that was based upon the New York Civil Code. New York Civil Code वो 1879 में कुछ खामियां होने के बाद 1863 का एक्ट आ गया. Then we have the Constitution of India. You know that the 7th schedule of the Constitution in Article 246 permits legislation by the central government, state government. तो list 3 के अंदर check करेंगे concurrent list के अंदर entry number 7 and 8 that deals with contracts. Entry number 8 deals with actionable wrong. This is related to specific relief. And entry number 10, trust and trustees, because the Trust Act भी आ जाएगा. Transfer of property 6 आ जाएगा. So these are the relevant entries for the purpose of our subject, which you should also know how the birth of Specific Relief Act and the connected laws took place. Article 246 of the Constitution in part 9, part 11, in part 11, there is a list 3 concurrent list. Okay, इतना समझिए. Now is the very famous, that is Bentham ने ये कहा था इसके बारे में, the law of specific relief, specific performance seeks to implement the idea of Bentham, who opined that, he says, the law ought to assure me everything which is mine without forcing to accept equivalent, although I have no particular objection to them. So how beautifully quoted, very aptly put it by him. The law ought to assure me everything which is mine without forcing to accept equivalents, although I have no particular objection to them. That means specific performance ke ilawa, you can also give me alternative damages, I have no objection. But my first preference is for specific performance of a contract, which I am rightly entitled to it. I have no objection to accept the damages in the event of specific performance is not possible. That is the essence of the act here. Now, today I will just take you through briefly the provisions of the act. If you open the Bear Act, we'll discuss it here. Why this Specific Relief Act is necessary? Because Specific Relief Act is actually not required. That was the subject matter of discussion in various judgment, earlier judgment of the Bombay Privy Council, when the relief sought claim in the Code of Civil Procedure, Transfer of Property Act ke andar substantially hai. Why this specific relief? Because then the idea was that here the plaintiffs, who seeks the relief, must exactly know the definite relief. Because the act is not, this is not an exhaustive act. I mean, it does not include each and everything. When you see the preamble, it doesn't say act to consolidate. It only says the act to define and the law relating to the kinds of specific relief. It is not a consolidating act. It is not going, that means the remedies which are available are not exhaustive. Innumerable. There may be other remedies available to you under the Code of Civil Procedure, under the Transfer of Property Act and elsewhere. तो यहाँ पे कुछ गिने चुने remedies आपको मिलेंगे, not all remedies. Now, what kind of remedies available to you? I will specifically take you through the provisions of this act here. That is the first chapter. Now, of course, the definition part, we leave it, not very important. I will discuss when necessary. The first chapter deals with recovery of possession of the property. Section 5 से लेकर section 5, 6, 7, 5 and 6 deal with recovery of immovable property. So ये तो CPC के अंदर भी है, CRPC के अंदर है, and I will tell you what kind of specific properties. So not every kind of property you can come. You cannot come and claim a property from the mortgager or mortgagee. You cannot come and claim property from a legatee. You cannot come and claim in a suit for administration. But a person, section 5 tells you what kind of remedy. Let us see. Now, when you open section 5, we'll see recovery of specific immovable property. Specific means a particular definite one. A person entitled to the possession of specific movable property may recover it in the manner provided by the Code of Civil Procedure. Now, all of you know that Code of Civil Procedure the jurisdiction clause is section 9 of the Code of Civil Procedure, which tells you what is a civil court, isn't it? Then the provisions of section 16, 17, 18, 19 tells you recovery of immovable property, which are situated in a particular jurisdiction of a court. Then the Code of Civil Procedure tells you the immovable properties, suit relating to immovable property you will find in order 34 of the Code of Civil Procedure, isn't it? The mortgage suit, such as suit for redemption of a mortgage, a suit for a foreclosure of a mortgage, suit for sale of the property, they are also falling within the ambit of the Transfer of Property Act. Please note that. Yeah. Then we also have in the Code of Civil Procedure the interpleader suit in chapter 35, and which is also connected to section 88 of the Code of Civil. In an interpleader suit, you know that the plaintiff does not have any interest. He doesn't claim interest. The property belongs to somebody. He can only ask for certain compensation or damages for example, a finder of a good under the Contract Act, a finder of a good in a bailment. Suppose you lost your diamond ring, mujhe mili. You announce an award, isn't it? The finder of my diamond ring, which is 5 crores, has been lost. If anybody finds, I will give 10 lakhs. So aapne mukhar gaye, so I can file and maintain a suit for a recovery of that. Though that is permissible under the law, that is under the Code of Civil Procedure. That is what the meaning section 5 connecting. Then there are certain suits under CPC also. A special interpleader suit bhi hai aapko. Then a special suit for the opinion of the court is given under section chapter 36, isn't it? Then summary suits are given under order 37. You know that here the CPC we comprehensively deal with. Then section 91, 92 suits whether the public nuisance take place. There is a parallel suits which are available here. So you cannot discard the suits because the Specific Relief Act cannot be read in isolation. It must be read in conjunction with the Code of Civil Procedure, which describes the various suits in the matter. So section 5 tells you specifically. Section 5 specifically tell you a person entitled to possession of specific immovable property recovery in the manner. So that is a manner of recovery. It's a procedural law of the Code of Civil Procedure, whereas the Specific Relief is a substantive law. Now, the rules relating to filing of a suit, you know that under order 6 the pleading, order 7 the plain, those you must be in conformity. That decree under order 20, then execution under order 21, they all will be enumerated and will be read in conjunction. So section 5 ho gaya. Then section 6 is very important. That is, it deals with 2 types of suits. A person who is in possession of an immovable property, irrespective of whether he has a title or no title, and he has been dispossessed by the owner or occupier and somebody without following the due procedure established by law, it is not possible to do. In India, even a true owner cannot take the law in your own hand. You know that. You know the judgment of Krishna Ram Mahale versus Shobha Rao's case judgment, which I had given you earlier, and we discuss here. So even a true owner must go to the court of law and file a suit. After the expiration of your agreement of leave and license or a lease, you cannot drive away your licensee or your paying guest that please get out. No, you cannot do that. Aapko court mein jana padega. And the procedure is you have to file a plaint in the Code of Civil Procedure. The plaint kaisa rahega? Pleadings under order 6 aapko mukammil karne padenge. Requirement karenge. Then choosing the court of your choice, you cannot choose. The Code of Civil Specific Relief Act suit ke andar, the courts are given in section 15, 16, 17, 18, 19, 20 of the Code of Civil Procedure. You cannot choose a forum of your choice by consent of the parties, but your suit must be filed in a court where the property is situated, immovable property, isn't it? That is what the language of section 16, it says that here. So when a person is dispossessed under section 6 without title, then such a suit must be filed within 6 months from the date of the dispossession. Please note that. Suppose for some reason or the other, your luck was bad, such section 6 का suit जो file किए within 6 months time dismiss हो गया. A court holding that you have no title, which is wrong. The court has no right to see the title of the parties under section 6, which is a summary procedure. In a summary procedure suit would lie against individual companies, not against government. Against the government of Maharashtra dispossessing you, your remedy may be writ petition. Your remedy may be something else, substantive suit, but not a suit under section 6. Please note that. And similarly, a decree is passed against you or for you, you cannot file it. This is not an appealable order because it's supposed to be summary, should be disposed of hurriedly. Now, dismissal होने के बाद, not to be disappointed that मैं हार गया case. You have a remedy to file a substantive suit within 12 years under Article 66, 67 of the Limitation Act and Section 6 of Clause 4 of the Specific Leave Act. Section 6 of Clause 4 check कीजिए आप, कहता है कि nothing in this section shall bar any person from suing to establish his title of the property to recover thereof. So, पहला suit आपका dismiss हो गया, that is a summary suit which is without title. You may be a person holding over. You may be a person tenant holding over under Transfer of Property Act after termination of your lease. Or you may be a person in occupation after termination of your leave and license under Section 52 of the Easement Act. But you are a permissive occupant. If you are a permissive occupant, you keep on extending your possession for about 12 years, and you are going to become, you can claim possession by adverse possession. Because under Section 27 of the Limitation Act, if the true owner doesn't file a case against you for eviction within 12 years, you have a right to claim possession by virtue of adverse possession. That is Article 66 and 65. Please note that. ये चीजें important है. So, if your suit is dismissed under Section 6, Clause 2, not to worry, you have a right to file a substantive suit under subsection 4, which will be a very important suit, which the court will consider your right title interest. Whether you are a owner, joint owner, tenant, subtenant, licensee, protected licensee, irrevocable licensee, mortgagee, mortgager, जो भी right है आपका exchange है आपका, that you can establish. So this is what Section 5 and 6 is the scheme of the Act. The difference between Section 6 के summary suit के अंदर and substantive suit में, substantive suit के अंदर अगर हार जाएंगे तो आप appeal will lie under Section 96. It's an appeal from decree. Whereas when you lose under a suit under subsection 1 and 2, that is summary suit, and there is no appeal. You at the most revision will lie under Section 115, which is a narrow remedy. But I will advise you to file a substantive suit under subsection 4. Okay? उससे भी शॉर्टकट एक है, तुमको मालूम ना, ये सिविल कोर्ट के अलावा सीआरपीसी के अंदर मजिस्ट्रेट को पावर है. When you are in possession, we have been dispossessed, when there is a breach of peace, section 145, 146 CRPC invoke कीजिए आप. वो भी quick remedy है. The magistrate has power to take cognizance of your complaint, and he will issue inquiry. He will hold inquiry, direct police to investigate, and he will put you in possession immediately. And he will also grant an order of injunction against the other side not to dispossess you, or he may appoint a receiver if he is not satisfied nobody in possession. But his injunction of the magistrate passed under section 145 and a receiver appointment under 146 will only last till a civil court is approached by the parties, one of the parties, for asserting the legal right, as only the civil court can decide right title interest. The magistrate in his limited jurisdiction under 145, 146 CRPC cannot decide title. Only breach of peace देखेंगे, and they will take a bond from you, undertaking that don't create a peace, nuisance and annoyance of any nature. So these are the remedies available to you under section 5 and 6. Anybody want to ask me question? Then before I proceed to section 7, which deals with the recovery of specific movable properties. So 5 and 6 dealt with a case under specific immovable properties. Now 7 and 8 deals with the specific movable properties. What are the movable properties? Now such a suit you will see under the provisions of the कोड ऑफ सिविल प्रोसीजर ऑर्डर 21 रूल 31 के देखेंगे आप, देयर इज अ provision for a decree for specific movable properties. Then order 21 rule 20 के अंदर भी provision है इसके अंदर specific movable properties. Then under the Indian Contract Act, bailment contract is a movable property that can be given. Then for a suit for rendition of account is a suit for movable property, isn't it? Then bailment of a contract under section 148 to 158. The finder of a good will come under this under section 7(8). आपने goods में you lost your diamond ring which was discovered by me. You announce an award that I will pay 1 lakh to a person finder of the good under section 168 of the Indian Contract Act. राघव जरा खोल ले तो मालूम पड़ जाएगा. 168 of the Indian Contract Act. You will find this provision called finder of a good. If I am not mistaken, if my memory is not lapsing, देखिए 168 खोल लीजिए for the benefit of everybody. ये 168 को जानना बहुत जरूरी है.
Yeah, should I read it, sir?
Please read it.
All right. 168 says, right of finder of goods may sue for specific reward offered. The
Yes.
finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner, but he may retain the goods against the owner until he receives such compensation, and where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward and may retain the goods until he receives it.
Yes, that is a movable property, right? Now this is also akin to provisions of section 88 खोल लीजिए CPC के अंदर. Section 88 read with order 35. Section 88.
Should I read it?
Yeah, interpleader suit पढ़ लीजिए जरा.
Yeah. Where interpleader suit may be instituted, where two or more persons claim adversely to one another the same debts, sum of money or other property, movable or immovable, from another person who takes no interest therein other than for charges or costs, and who is ready to pay or deliver it to the rightful claimant, such
Yes.
other person may institute a suit of interpleader against
Yes.
all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made, and of obtaining indemnity for himself.
Exactly. So यहाँ पे you have no interest except the fact that you're recovering your compensation or reward is akin to section 168 Contract Act suit, and this will be filed under provisions of section 7 and 8 of the Specific Relief Act. Please note that here. और इसका procedure 88 का will be interpleader suit. You are read in the Code of Civil Procedure, that is order 35. I won't be reading it. You can, for the benefit of the student, just point it out. Order 35 दिखा दीजिए हमको.
Yeah, I think everyone has the book and the Bare Acts along.
Yes, देख लीजिए आप. देख लीजिए. I won't be wasting your time reading the section. That's of course CPC. You are reading this year. हो गया. Okay, these are the example, and our specific movable property, the partners are disputing. They do not want to go for dissolution. They may go for rendition of the account. ये partner is not giving, and it's a suit for movable property. So यहाँ पे लिखा गया देखो, a person entitled to the possession of specific movable property may recover it in the manner prescribed under the CPC. So CPC के relevant provision, please note it down. Order 21, Rule 31. लिख लीजिए आप. गौरव point out कराइए उनको. Order 21, Rule 31.
सर सब साथ साथ देख रहे हैं, आप बताते रहो.
देख लीजिए. Then order then the provisions of order 20 and order 20 rule 10 CPC. Decree is passed order 20 के अंदर. These are the things which you are required to note in such matters. Yeah. And a suit for specific performance CPC के अंदर appendix A check करेंगे आप. Appendix number 47 में item number 47, 48 check कर लीजिए आप. Student को भी चाहिए देखना चाहिए. They should know where is the format of the specific performance suit.
Yeah, appendix A, 47 and 48.
47, 48 specific performance suit would lie here. Even a breach of agreement is a item number 13 देख लीजिए आप. Breach of agreement agreement जो 13 and 16. 13, 16 is that उसमें डिफेंसेस फॉर डिफेंडेंट के लिए आइटम नंबर अपेंडिक्स ए के अंदर आइटम नंबर डिफेंसेस 13 है. So these are all which as a young lawyer you should be in a position to lay your hand. Then decree for specific performance you will find in schedule D12 appendix D check करो. D for Delhi 12 12 number. Decree for the rectification of instrument है उसके अंदर. These are the relevant things which you should require. I won't much waste your time in this regard. Item number देखो explanation check करें आप. Section 7 का explanation कहता है a trustee may sue under this section for the possession of movable property for the benefit of the interest in which a person for whom he is a trustee is entitled to. Now this suit, because a trustee is acting in a fiduciary capacity, कोई ट्रस्ट पब्लिक ट्रस्ट हो, कोई हिंदू ट्रस्ट है, मुस्लिम ट्रस्ट हो, क्रिश्चियन ट्रस्ट के अंदर और इंडियन ट्रस्ट एक्ट के अंदर, somebody has used up the property, taken over the property, such a suit would lie under the Limitation Act section section 10 check करेंगे आप of the Limitation Act relevant section where there is no limitation period for such a suit. Please find it. Section 10 check करो. You must remember that Limitation Act, this is one section which does not prescribe limitation. Suit against trustees and their representatives, notwithstanding, पढ़ लीजिएगा, a very important section.
Yeah, I'll read it. Okay, Section 10 of the Limitation Act 1963 says, suits against trustees and their representatives. Notwithstanding anything contained in the foregoing provisions of this act, no suit against a person in whom property has become vested in trust for any specific purpose or against his legal representatives or assignees, not being assigns for valuable consideration for the purpose of following in his or their hand such property or the proceeds thereof, or for an account of such property or proceeds shall be barred by any length of time.
So limitation लगता ही नहीं इसके अंदर. देखिए, if you are acting in a fiduciary capacity, somebody is occupying trust property, movable or immovable, unlimited period, because it's a public property. समझे ना आप? Is a very important section which you must remember this man. Now item number explanation 2 भी देखिए. A special or temporary right to present possession of a movable property is sufficient to support a suit under this section. A special or temporary right. Now, what are the special rights like I gave you? Special right can be under the provisions of section 168 of the Contract Act, that the finder of a good, or a special right under the CPC section 88 interpleader suit. These are special right conferred to you, which you must remember it here. Section 8 पे आ जाइए. Liability of person in possession not as owner to deliver persons entitled to immediate possession. Now, every person under section 8, somebody who is not a owner, suppose if I had taken your pen, which you had borrowed from your father or your brother, and it's my duty not to withhold it. My purpose is over, I must return it back. If I don't return it back, you have to file a suit here under the provisions of section 8 and get it here. Even from me or somebody from my agent, my wife, my daughter, anybody can file the suit here in this regard. Please note that here. So these are the, now so far as come back to section specific performance of contract. Now यहाँ पे suit relating to movable and immovable property हो गया. Now chapter 2 deals with a very important specific performance of a contract, which is very, very important. How the specific performance is granted, denied, you come to know from in section 10 से लेकर 14, 16, 17, 18, 19. एक glance देख लेंगे अंदर. I will tell you that here. Now main section is here, number 3. Except otherwise provided, where to claim the chapter so and so. ये इतना important. Section 10 importantly. Specific performance in respect of a contract shall be enforced by a court subject to provisions of 11.2 and 14 and 16. Now 11.2 कहता है कि specific performance will not lie where the trustee has discharged duty in excess of his powers. Okay, trustee, then you can claim damages. अब ट्रस्टी ने अब ट्रस्टी ने आपका कोई क्या नाम है आपसे ज्यादा पगड़ी ले लिया, isn't it? पूरा पैसा हजम कर लिया उसने. You will not be in a position to recover it. You can claim damages. You cannot say restore the pagri back, whatever reason here. But if he has taken a land and encroach upon it, you have a right to claim it here. Section 10 ke andar, where this is a suit dealing with a specific performance of a contract. Now, 11 is a case dealing another situation. It deals with trustee ho gaya. 12 is a part performance of a contract where a person is plaintiff is ready and willing to perform. A defendant is not willing to perform. Suppose there are two contracts under which you have shown your willingness to deliver goods, and another contract the defendant is refusing to do that. You have a right to go and seek a specific performance of your contract, and in respect of his contract, you can claim damages in the matter. Because you can terminate his contract and claim damages under Section 73 of the Indian Contract Act. There is no bar as such here. Then there is a specific bar under Section 14, which says that contracts which are not enforceable, when you kindly see that, which contracts are not enforceable. You cannot seek generally in a suit for specific performance. If a builder has not given you a flat, you will file a suit for declaration that the agreement is valid, subsisting, that may be specifically performed. That the builder may be directed to put you in possession. He may be directed to execute conveyance. He may be directed to do all acts relating to registration. So these are all remedies along with the specific performance. Uska relevant section aapko milega aapko, which you can seek all these remedies is a little dur hai iske andar. That is Section 22. Section 22 check kare aap. Section 10 and 11. Section 10, 11, 12 should be read along with Section 22. Power to grant relief of possession, partition, refund of earnestment. Please note that notwithstanding anything to the contrary contained in the CPC, any person suing for specific performance of a contract to immovable property may ask for possession, partition, separate possession, property in addition to performance. So like under Order 2, Rule 2 CPC aap padhe hai, a plaintiff must sue for the entire cause of action. You cannot relinquish any portion of the claim. If you relinquish, your suit is barred. You need to take permission of the court. Order 2 के अंदर वो आपको तो मालूम है आपको. तो यहाँ पे when you are entitled to specific performance of a contract for conveyance, don't say that I am only entitled to declaration that the agreement is valid, subsisting. What is the consequential relief you want? Main possession चाहिए. Possession should be asked for. If you are seeking possession of a partition भी लेना चाहिए. Partition by meets and bounds ke andar. So these are all ancillary. If you don't seek them, and your suit will be barred under the provisions of Order 2, Rule 2, which must be asked for. So Section 10, 11, 12 should be read along with Section 22. So because the court will mold the relief the way you want it in the matter. Then under Section 14, the clause A says. Clause A says that specific performance will not be allowed where there is a substitution of a performance of a contract under Section 20. Now, this is a new section which has been added pursuant to the amendment of the year 2018. Now, here, see, is a very important section, substituted performance of the contract. If A cannot perform the contract, B can delegate the contract to B and C and D, anybody else. So on that behalf, B, C and D, if the breach take place, specific performance cannot be asked for. What can be asked is only damages. Now this is also, there is also provision under the Indian Contract Act. You have heard it, novatio of a contract. पढ़े ना? Section 62 जरा देख लीजिएगा और Section 62 of the Indian Contract Act. (62) Effect of novatio, rescission, alteration of a contract. Mila? If the parties to a contract agree to substitute a new contract for it to rescind, alter, the original contract need not be performed. He stand discharged. So you will not be allowed to ask for a specific performance. At the most, in the event of their violation, infraction of the agreement from the third party agent to whom the contract has been substituted. See section 20 padhiya, without prejudice to the generality of the provisions contained in the Indian Contract Act. So section 62 laga dijiye idhar aap. And except as otherwise agreed upon, the parties where the contract is broken due to non-performance or a promise by a party, then a party suffering breaches. So yahan pe ultimately you are entitled to damages and not specific performance. You cannot say that the builder was supposed to give me a flat. When a flat बेच दिया, I told दिया with the consent of the land with the owner to XYZ. अगर उसको भी flat नहीं दिया उसने, whatever reason may be, and maybe impossibility of a contract under section 56 of the Indian Contract Act, वो बोले कि plans pass नहीं हो गए, there's a calamity, workers available नहीं हैं, and FSI level नहीं मिल रहा है. In such an event, your remedy is to claim damages. Okay, that is a section 14, 14A. 14B को आ जाइए आप. The contract performance of which involves the performance of continuous duty which the court cannot observe. So if the court is required to perform continuous duty, for example, a court receiver is appointed in a partnership dispute between two partners are fighting. So the court is not going to specifically perform one of the requests of the plaintiff or defendant, that the defendant should be specifically directed to perform and run the partnership as it is and go on with the contract. No, you cannot do that. He may not be having funds. You cannot do that. Court cannot be doing supervision. Court is not going to be the agent of the parties. So it is impossibility to perform the contract. Specific performance is not possible in such a scenario. So यहाँ पे क्या करेगी court here? Similarly is the case when a plaintiff and defendant in a matrimonial suit, for example, the wife has obtained a decree for a restitution of a contract, husband is not willing to perform. You cannot tell the court, you come and watch it, execute karo, dekho aata hai, kab jata hai, kab nahi aayega, whether he is willing to join me or not, participate. This is too much for the court, isn't it? Such contracts are void and cannot be performed, and it is specific performance not possible. Similarly, see, dekhiye, contract which is so dependent on the personal qualification of parties that the contract cannot be a specific performance or material. Suppose a minor has contracted to sell you his house to the defendant, to the plaintiff. Minor की उम्र छोटी थी. On behalf of the minor, उसके uncle ने sign कर दिया agreement. Okay, the minor will sell the agreement to you after 6 years. After 6 years के बाद minor after attaining majority, he will change his mind. A minor is capable of giving consent. A minor's contract is good only for his benefits, not for his losses. So the minors can say, man, take a somersault. I am sorry, I will not do that. So on account of here the qualification, the age of the person, the contract is impossible to perform. Specific performance, the plaintiff cannot go there. Minor should be directed to specifically perform the contract. So यहाँ पे उड़ जाएगा contract. समझे ना आप? Then ये last में contract which is in itself terminable. So suppose, for example, you are a landlord, owner, I am your licensee. You are creating a license under section 52 of the Easement Act, section 52, for a period of 11 months in Delhi or Bombay. समझे ना? अगर execute करने के बाद he is not registering the contract or performing, you cannot go to the court for specific performance, because it is going to be determined, because licensee is a permissive occupant, he does not get any right title interest. Under section 52 of the Easement Act, a licensee is a mere occupier, it's a privilege, it's not a right, it's terminable. Similarly, a tenant at sufferance under section 111G of the Transfer of Property Act, whose lease has been expired, cannot say that we orally agreed to extend the lease, or there cannot be oral assurances. So it is a determinable contract, cannot be specifically performed, because the discretion of the court in performing such a contract is justified, because it may not be arbitrary. It is with great circumspection and caution. The court, is it possible to do or not? वो करेंगे, करने से फायदा है नहीं क्या? Is it a waste of time? नहीं करेंगे. So 14 years speaks of engagement of experts. This is like without prejudice to the generality, यहाँ पे CPC के अंदर भी provision है, court will appoint expert. Expert कौन है? Court commissioner. They'll be for determining the mean profit, they'll appoint an architect under Order 20, Rule 12C. He will give evaluation whether the building is in a good condition, bad condition. A structural engineer, expert report देगा. Then Order 26, Rule 1, commissioner appoint होगा. There'll be scientific expert to study DNA report देखने के लिए. Isn't it? These are all court will appoint experts here, both under the provisions of CPC Order 39, Rule 7 में provision है, and Order 26, Rule 1, 2, 10, 15 तक ये भी provision है. So similar provision has been brought here under Section 14A of the Specific Relief Act, which shows that Specific Relief Act is not only a substantive piece of legislation giving right at interest, it is also more or less a procedural enactment where certain procedures are prescribed apart from, in addition to the procedures which are already laid down in CPC. CPC के बारे में काफी जिक्र होता है इसके बारे में. Section 5 में भी होता है, 6 में भी, 7 में भी, तो CPC में जो mention किया. So nobody can, no substantive law can survive without the procedural law of the CPC in civil cases. Now 15 check कर लीजिए आप. Who may obtain specific performance? Who can obtain? Who has the locus standi? And everybody cannot be. It is not like a suit under Order 1, Rule 8 CPC in a representative capacity. Any Tom, Dick, and Harry can file it. It is not even a suit like the under Section 88, which we read it out right now, Order 35. Anybody can file it. Only यहाँ पे specific people, a party who has been aggrieved, जिसका contract has been terminated. The builder has refused to give you possession. You can go there. समझे ना? आपका contract I have been refused. I have refused to obey the contract. A party representative principle in the matter. So the definition, what is a party, a person, is not defined in CPC or under the provisions of Specific Relief Act. उसके लिए आपको General Clauses Act check करना पड़ेगा. और General Clauses Act, wherever the Act any कहाँ भी नहीं मिलेगा आपको General Clauses है. General Clauses Act भी नहीं रहेगा तो the courts, Supreme Court accept the dictionary meaning. Then the other persons who are entitled to specific performance, देखिए name दिया गया यहाँ पे. B के अंदर representatives हो गया any party, उनके C हो गया settlement, marriage, compromise, doubtful between so and so, between the parties, beneficiary entitled to certain marriage contracts can be specifically performed. You agreed to give certain things. Then D के अंदर contract entered into by tenant for life in due exercise of power. Now this is a perpetual leases under the Transfer of Property Act. Now perpetual lease can be enforced. Revisioner in possession where the agreement of a covenant is so and so. A revisioner is a person where a lessor, after determination of the lease, mentions that the property can be sold to the lessee for a period after a period of 50 years, 60 years, 70 years, or termination, provided he gives the market rate, agreed rate, 100 rupees per square yard. So he becomes the revisioner when the right title would be it will be reverted back to the lessee in the matter. Okay. Then when it limit now FA के अंदर limited liability partnership भी आ चुका है. Now under the limited liability partnership, the gamut of this act is that which came in the year 2018. Partners' responsibility is not joint and several, unlike in the Indian Partnership Act. Now, to the extent of his contribution is liable, not otherwise. That is why even 2 persons are minimum required under the joint liability partnership in this regard. So these are the persons who can obtain a specific performance of a contract. Then personal bar to relief, personal contract cannot be specifically performed, which we know that here. Substituted contract cannot be done under Section 20, isn't it? These are the.
Sir, can I interject for a second?
जी बोलिए.
So some of the people are finding it too fast to catch up with the speed. So can we go a little slow?
अच्छा, little slow जाऊंगा, लेकिन we will not be able to cover today in the lecture. Okay, no problem.
We'll continue in another lecture, but थोड़ा slow चलते हैं so that everyone can.
Okay. Okay. So the persons who are not, who cannot, the persons bar to पर्सनल बार टू स्पेसिफिक परफॉर्मेंस सेक्शन 16 देखिए इसके अंदर. नाउ सेक्शन 16 टेल्स यू ऑल्सो 20 अगर सब्स्टिट्यूशन हो गया, कॉन्ट्रैक्ट आपने नहीं एग्जीक्यूट किया, कर नहीं सके, आप पावर ऑफ अटॉर्नी किसी और को दे दिए, आप डेलीगेट कर दिए और डीड ऑफ असाइनमेंट कर दिए, वो आदमी किया, then that person cannot come and say that in the event of a breach you give me specific performance. His remedy is only damages, isn't it? His remedy is damages. Then यहाँ पे where the contract involves payment of money, it is not essential for the plaintiff to actually tender the defendant deposit in the court money when erected. So when a suit is filed for specific performance, suppose you are the owner of a flat which you agreed to sell it to me. I agreed to pay the contract. You refused to give it to me. I moved the court of law and filed a suit for specific performance. So merely normally saying I am ready and willing is not sufficient. And you have to show that readiness and willingness by depositing money in the court or paying it to the other side. अगर वो check लेके refuse कर दिया, then you are no problem. आपकी remedy available है. But formally it was not necessary to deposit them. It was necessary to deposit money first in the court. अभी explanation कहता है, but keep the money ready unless the court tells you don't deposit. There is no need to deposit. Otherwise, generally under the provisions of Order 39 Rule 10 CPC भी देखेंगे आप, there is a power of deposit. 39 Rule 10 खोल लीजिए आप CPC के अंदर भी.
Should I read it, sir?
Yeah, Order 39 Rule 10.
Okay, just a second. Yeah, Order 39 Rule 10 says deposit of money, etc. in court, where the subject matter of a suit is money or some other thing capable of delivery, and any party thereto admits that he holds such money or other thing as a trustee for another party, or that it belongs or is due to another party, the court may order the same to be deposited in court or delivered to such last named party with or without security, subject to further direction of the court.
Yes. So this is an interlocutory order which is normally passed by the court before the final hearing of a suit. Please note that. Final hearing will take 5 years, 10 years, 15, 20 years. Till then you will not suffer. बोलेंगे, you should be, if he must show his willingness. Let him deposit the money. If such an order is passed, he must deposit it. If there is no order is passed, there is no need to deposit. The suit may go on. But he must continue his readiness and willingness. तो प्लेन के अंदर लिखना पड़ेगा प्लेंटिफ को, this is a suit for specific performance of a contract. Namely, the defendant builder has executed a contract with me for a consideration of rupees say 1 crore to put me a flat, to give me a flat within a period of 6 months in the city of Bombay or Delhi. And I have paid my entire money and the last contract is pending, which I am ready and willing to pay. But I believe OC is ready. But I believe that the defendant is not willing to give me part with possession. I believe he is asking for more money, which is not permissible. He is demanding more money, not permissible. And he has sent me a letter of termination saying that if you don't give excess money, I hereby terminate your contract. Then immediately within a period of 3 years, please note that from the date of your termination, under relevant article is Article 55 and 56 of the Limitation Act. You must file a suit. Must file a suit for specific performance for a declaration number 1. वो declaration will cover करेगा कहाँ पे? The CPC जो इसमें आएगा section 34 में आएगा of the specific relief act. Declaratory decree मारेंगे ना आप इसके अंदर. So your first prayer will be against your builder that this honorable court be pleased to declare that. मिला आपको 34?
Yes, sir. Should I read it?
Yes, please read it out.
34 of the Specific Relief Act under Chapter 6 says discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may, in its discretion, make therein a declaration that he is so entitled, and the plaintiff need not, in such suit, ask for any further relief, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
Yes. So, अगर आपको बिल्डर ने फ्लैट नहीं दिया, so it is just not you are filing a suit for specific performance. You have to first seek a declaration. Declaration that the agreement between you and the defendant is valid, subsisting and subsisting and binding on both the parties. ये लिखिए, number 1. Number 2, the letter of termination which has been given. The letter of termination which has been given by the builder is illegal and invalid, and the same be cancelled. Section 31 में आएगा. Cancellation of an instrument. The builder has executed a contract and believe with the defendant number 3 who has no right title interest. समझो ना, अब फ्लैट आपने बुक किया और builder is selling it to me. So not only for declaration that your agreement is valid, but the agreement which the builder executed with the third defendant is invalid, illegal, and the same be cancelled under section 31. 31 पढ़िए गौरव.
Yes, sir, just a second. 31 of SRA says that when cancellation may be ordered, any person against whom written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled. If the instrument has been registered under Indian Registration Act, the court shall also send a copy of its decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his book the fact of its cancellation.
So your suit for specific performance will include here, number 1, prayer A, that this honorable court be pleased to declare that plaintiff's agreement with the defendant number 1 builder is valid, subsisting and binding on all parties. Number 1. Number 2, that this honorable court be pleased to declare that the agreement which the builder has entered into with party number 2 is sham, colorable and bogus, and the same be cancelled as it is injurious to the plaintiff, right? Which is a subsequent agreement. Okay, the third. तीसरा prayer रहेगा that this honorable court be pleased to direct the defendant to specifically perform the part of the contract and put me into possession. That is a relief you have to seek under the provisions of the act. Put into possession and convey the property. Suppose already he has put into possession third party, that this honorable court be pleased to order and decree the defendant number 3 to quit, vacate and hand over quite vacant peaceful possession. हो भी add कीजिए आप. Please note that prayer will come here under the provisions of section. अभी पढ़ा मैं आपको कभी section 26, isn't it? So 22, section 22, clause B. देखो clause A, power of the court to grant possession, partition, so prayer C क्या रहेगा आपको? That this honorable court be pleased to order and decree the defendant number 3 to quit, vacate, hand over quite vacant peaceful possession of the premises to the plaintiff. यहाँ पे both the defendant number 1 and 3 should be direct to vacate. Suppose if he has been in possession for longer time without your knowledge, plaintiff is also entitled to mean profits. क्या बोलते हैं? Plaintiff is entitled to mean profits for the wrongful occupation of the defendant number 3 at the instigation of defendant number 1, that this honorable court be pleased to direct an inquiry under order 20 rule 12C for determination of mean profit. CPC खोलिए, order 20 खोलिए, रखो. ऑर्डर 20 रूल 12C खोल लीजिए आप.
Yeah, should I start reading?
Yeah, please. Order 20, Rule 12C.
Order 20, Rule 12. A तो है, अच्छा 12C. Okay.
12 पढ़िए. 12. Order 12 से पढ़ चाहिए आप.
Yeah, got it. Decree for possession and mean profits.
Yes.
Where a suit is for recovery of possession of immovable property and for rent or mean profits, the court may pass a decree for the possession of the property, for the rents which have been accrued on property during the period prior to the institution of the suit or directing an inquiry as to such rent, for the mean profits or directing an inquiry into mean profits, directing an inquiry as to rent or mean profits from the institution of the suit until the delivery of possession to the decree holder, the relinquishment of possession by a judgment debtor with notice to the decree holder through the court, or the expiration of 3 years from the date of decree, whichever event first occurs.
So, आपके कितने प्रेयर हो गए इसी सूट के अंदर? Number 1, suit for declaration that your agreement is valid and subsisting, section 35. Suit for declaration that the agreement with the builder with defendant number 2 is invalid and be cancelled, section 31. Then suit for mean profits, order 21, rule 12C. Then the suit for specific performance of a contract, directing the defendant to specifically perform. Specific performance to put into possession, section 22 read with order 12A पढ़िए CPC का, order 20 rule 12A.
12A says decree for specific performance of contract for the sale or lease of immovable property, where a decree for specific performance of contract for the sale or lease of immovable property orders that the purchase money or other sum be paid by the purchaser or lessee, it shall specify the period within which the payment shall be made.
Yes. So वो डिक्री पास हो जाएगी कोर्ट के अंदर. Then order 2135 पढ़िए आप, डिक्री फॉर इमूवेबल प्रॉपर्टी हो जाएगी. In order 21 rule 35, you should remember this. 35. Order 21 rule 35.
Order 21 rule 35 of CPC says decree for immovable property. Where a decree is for delivery of any immovable property, possession thereof shall be delivered to the party to whom it has been adjudged, or to such person as he may appoint to receive delivery on his behalf, and if necessary, by removing any person bound by decree who refuses to vacate the property. Where a decree is for the joint possession of immovable property, such possession shall be delivered by affixing a copy of warrant in some conspicuous place on the property and proclaiming by beat of drum or other customary mode at some convenient place the substance of decree.
Okay, देखिए, in a suit like this, you have got at least 4 to 5 substantive remedies. Now, by the time the court passes these remedies, it will take maybe 5 years, 2 years, 3 years. उसके अलावा क्या करेंगे आप बीच में? Pending the hearing and final disposal of the suit, that this honorable court be pleased to appoint a court receiver, High Court Bombay, a court receiver, High Court Delhi, court receiver of this court, to take possible possession, physical possession as a custodial legis. Order 40 का you'll be invoked. Order 40 पढ़िए CPC का. Before or after decree, the court can pass this order.
Yeah. Order
40
is appointment of receivers. Appointment of receivers, where it appears to the court to be just and convenient, the court may by order appoint a receiver of any property, whether before or after decree.
Underline this word, before or after decree. That means you can go even at the interlocutory stage, even immediately after filing of the suit. Please, yeah, to remove B, to remove any, बाद में पढ़िए.
To remove any person from possession or custody of the property. Third, commit the same to possession, custody, or management of the receiver. And fourth, confer upon the receiver all such powers as to bringing and defending suits for the realization, management, protection, preservation, and improvement of the property, the collection of rents and profits thereof, the
Yes.
application and disposal of such rents and profits, and the execution of documents as the owner himself has, or such of those powers as the court thinks fit.
Yeah, this is a called interlocutory order. This is normally couched that pending the hearing and final disposal of the suit, that this honorable court be pleased to appoint a court receiver of this honorable court or any advocate, officer of the court to take physical forcible possession of the premises from the defendant or any person found therein, and appoint the plaintiff as the agent of the court receiver dispensing security and royalty. ये प्रेयर रहेगा आपको, otherwise you are liable to pay. इसके अलावा उसी पावर में सेक्शन 94 खोल लीजिए सीपीसी का, सेक्शन 94 खोल लीजिए.
Yeah.
Supplement.
Section 94
Yeah.
says, talks about supplemental proceedings.
उसके अंदर उसमें you are going to invoke also those two. Number one, 94 के अंदर उसमें दो, 94 के अंदर C grant of injunction, D appointment of receiver. C पढ़िए आप.
C is grant a temporary injunction, and in case of disobedience, commit the person guilty thereof to civil prison, and order that his property be attached and sold.
कितना
D,
पावर? Yeah, D.
D, appoint a receiver of any property and enforce the performance of his duties by attaching and selling his property.
Yes. Then last में make such other interlocutory order. Interlocutory mean an order passed during the pendency of a suit. Now इसका heading शुरू होता है, in order to prevent the ends of justice from being defeated and the court may. This is the language used in also section 151. 151 जरा खोल लीजिए CPC का.
Yes. 151 says, saving of inherent powers of the court. Nothing in this court shall be deemed to limit or otherwise affect the inherent powers of the court, to make such orders as may be necessary for ends of justice or to prevent abuse of process of court.
Yes, these are all orders. Now, इसके अलावा specific relief act में you can also seek a mandatory order. Now, mandatory order, please note that here, section 37 खोल लीजिए आप. 30 section 39 खोल लीजिए. Such power was exercised by the Supreme Court. I will tell you when.
Yeah. 39 of the Specific Relief Act says mandatory injunctions. When, to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing, the court may, in its discretion, grant an injunction to prevent the breach complained of and also to compel performance of the requisite acts.
So court may also can give mandatory injunction. Now 37 padhiya. Temporary perpetual injunction.
37 of the Specific Relief Act says temporary or perpetual injunctions. Temporary injunctions are such as are to continue until a specified time or until further order of the court, and they may be granted at any stage of the suit and are regulated by the CPC. A perpetual injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from commission of an act which would be contrary to the rights of the plaintiff.
Yeah, इसके अंदर perpetual order ऐसा रहेगा आपका, that this honorable court be pleased to grant a perpetual order of injunction directing the defendant not to enter or remain upon in the suit premises in any manner whatsoever. Okay, वो रहेगा prayer, that will be a decree. But temporary injunction are governed under the CPC order 39 rule 1 and 2 and order 40 and section 94 अभी पढ़े हमने. So these are all you are going to invoke in a suit for specific performance. Now the Supreme Court says that here appointment of a receiver is a serious business. This cannot be appointed as a matter of course. But in rarest of rare cases, in a particular cases, nothing can be prevent the court from passing an order, appoint a receiver and pass a mandatory injunction, remove a person. Now, in a case where the court, Supreme Court appointed, granted mandatory injunction, suppose the property in one particular matter, that is a Dorab Kawasji versus Kumi Sorabji's case, and that is of the year 1990 Supreme Court. Two brothers were occupying a joint dwelling house in Bombay, which property is now purchased by Sachin Tendulkar in Bombay at Perry Road. It was belonging to a Parsi family initially. Now the Parsi family, one of the brothers sold it to Rahejas, the builder, during the pandemic. The Rahejas who came and occupied the portion of the bungalow. The other brother objected. It's a joint family house. How can you come and object? So one of the brother filed a suit in the City Civil Court, Bombay, that Rahejas should be directed by a mandatory injunction to remove themselves from the premises, and by a perpetual order not to enter remain upon the premises. The City Civil Court, Bombay, granted the decree. The High Court, in its appellate power under 104 CPC, reverse it. The Supreme Court confirms it. Please open this judgment of Dorabji's case. Dorab Kawasji Warden versus Kumi Sorab the Warden. मैं भेजा हूं आपको.
Let me check, sir.
Yeah. वो आपको मैं भेजा हूं आपके ग्रुप के आपके लिए. Dorab Kawasji Warden versus Kumi Sorabji Warden. It's a very interesting matter. At the interlocutory stage, the Supreme Court told the builder, you have no right to occupy the dwelling house because there's a bar under Section 44 of the Transfer of Property Act. I will take you through.
Yeah.
Yep.
Should I read the paragraphs that you had sent?
Yes, please, that you read it. That's enough.
The Supreme Court, relying on 24 Halsbury Law of England, 4th edition, para 488, and the other English and various High Court rulings, held that a mandatory injunction can be granted on an interlocutory application as well as at the hearing, but in the absence of special circumstances, it will not normally be granted.
Correct.
In this matter, mandatory injunction was granted at interim stage in a suit filed under 44 of the Transfer of Property Act, directing the stranger transferee to vacate the portion of joint dwelling house of the appellant's family, which he had purchased from one of the joint owners of undivided family, resulting in filing of suit under 44 of TPA by other members of joint family opposing the presence of stranger transferee in their joint family dwelling house.
Yeah, that is very interesting, but we'll share it with the group, the people. So 44, remember kijiye aap. So a joint family house cannot be sold to strangers. It is the prerogative of now under the Mohammedan law, the Muslim cannot sell a house to strangers. First preference should be given to family members or the neighbor, isn't it? Even Transfer of Property Act may be provision. Which is the provision, any of you remember?
About, sir?
The first preference, the property cannot be sold to strangers. Mohammedan law ka rule hai, exactly this is.
The preemption rule?
The law preemption. So, following the preemption rule, Section 44 is couched. 44 applies to only joint dwelling house where the joint family property is staying, two brothers, sisters, family members. One of the brothers cannot sell his right to strangers. Stranger may purchase it, but he cannot come and occupy. His right will only come into play when he sues for partition of the suit. Then another case, recent case, the Supreme Court, where in a case of Hamdard Dawakana, where a junior family trustee was appointed, excluding the right of a senior trustee, or Delhi High Court के अंदर suit pending था. Application was made, the senior man should be allowed to occupy the seat of a chief trustee. Delhi High Court rejected it, Supreme Court granted it. That is a Hamdard Dawakana, the judgment of Supreme Court. 3rd April 2019. देखो Hamad Ahmad versus Abdul Majid. वो जरा पढ़ के तो सुना लीजिए आप. Hamad, yes.
Let me look for it.
Judgment of Justice Gupta and Justice Hemant Gupta, that is 9th of July 2019. When the rule of primogeniture was not applicable to Mohammedans. that you can share with the group. So more or less substantially the specific relief act के अंदर कैसे relief होते हैं, you can ask for it.
Yeah, we'll share that.
Yeah, वो कर लीजिए आप. That is the, so the it is up to the lawyer, the young lawyer, how to because you have to bring in a suit for specific performance, you are bringing into action play not only the provisions of the entire the specific relief act, the code of civil procedure. So almost entire in a suit like this, sub provisions to play ho gaya pe. So that is what, so more or less learn. Then I will explain to you when in section 41 deals with cases when injunction can be refused, when cannot be granted. That is there are 5-6 circumstances which I will not go through. You may go through that, where the person must come with clean hand, cannot suppress material fact, and he should not be, you cannot restrain the judicial remedy available. You cannot stop someone from suing against you for defamation, another remedy, or malicious prosecution. Yes, there is a multiplicity of proceeding, you may say that. वो 41 के अंदर check कर लीजिए आप. Then lastly, there is a 42 के अंदर, where injunction in negative covenant can also be enforced, is important. But another important section which has been added is section 20A, is very important, which you must go through. That is 20A, please देखिए. Special provision relating to infrastructure project where no injunction can be granted. Please note that. वो जरा पढ़ लीजिए आप. Section 20A पढ़िए आप.
Special provisions for contract relating to infrastructure project. No injunction shall be granted by a court in a suit under this act involving a contract relating to an infrastructural project specified in schedule, where granting injunction would cause impediment or delay in progress or completion of such infrastructure project. Explanation: for the purposes of this section, section 20B and clause HA of section 41, the expression infrastructure project means the category of projects and infrastructure subsectors specified in the schedule.
Schedule check कर लीजिए. बस जैसे कहा schedule check कर लो, उसमें लिखा है road and bridges last में, after section 43 के बाद, 44 के बाद, repeal के बाद है वो. Schedule, road and bridges, they cannot be injunction. Ports, no injunction. Shipyard, no injunction. Inland waterways, no injunction. Airport, railway, urban transport, electricity generation, oil pipe, solid development, wherever these are public utility services, you cannot seek an order of injunction, which otherwise normally the courts were granting easily in the matter. This is what the specific relief act. Now the amendment which has been carried out, I will just take you through the relevant amendment, which is when you section 218 के अंदर the amendment act of which came into effect on 19th of September 2018. Now it tells you under section 6 के अंदर the expression what is added is not only the defendant through who has been dispossessed through his possession agent, any person through whom he has been in possession. So it may be your father may be in possession, son may be in possession, wife in possession. They are included to make it to make the relief available to everybody in the family. That is section 6 का amendment. Okay. Section 10 के अंदर that is a specific performance of a contract के अंदर वो exclude किया. 11 to 14 and 16 वो nearly add किया गया. Our section 14 के अंदर what is added is here, that is a contracting not specifically enforceable is a new section which has been added. Our section 20 has been added recently, which said that substitution of a contract जो novatio हो जाएगा उसके अंदर you cannot seek specific performance, सिर्फ damages आप claim कर सकते हैं. Then 14A के अंदर power to engage expert डाला गया है. Isn't it section 14? That is, you can appoint a handwriting expert, you can appoint an architect, you can appoint a doctor, you can appoint DNA expert to see the various projects. Then amendment of section 15 भी हुआ इसके अंदर, where 15 के अंदर limited liability partnership को भी लाया गया है. It has been roped. और section 16 के अंदर clause A के अंदर specific performance के अंदर when it was formerly may perfume था, अभी court shall has been given. You can insist the court wherever it is may, the court shall perform it. Amendment 19 के अंदर भी यही हो गया है अभी, limited liability partnership को incorporate किया गया है. our section 20 के अंदर I just read out to you, substitution of a new contract as brought into picture, which is very important. So wherever our section 20A has been added to bring the new infrastructure project, there is a special courts have been added. Section 20B के अंदर civil court, high court के अंदर there is a special court which can take up the matter expeditiously. There is now a direction the matter should be disposed of within a period of 12 months or 6 months, so and so. That is 20C के अंदर. This is with a view to see that here specific performance should be allowed to go on immediately. Not 21 के अंदर आप देखेंगे word shall has been added, may गया है. Mean whenever there is a suit for specific performance, it was the court may give the specific performance. Now the court shall specifically perform the contract if it is satisfied that from the surrounding circumstances and the intention of the parties that the plaintiff agreed to perform the part of his contract, the court may not perform, the court shall perform, shall grant the specific performance. So 25 के अंदर भी act के अंदर the word, figure, arbitration, conciliation. You know that under the Arbitration Conciliation Act में all arbitration matters are not amenable to the Arbitration Conciliation Act. So certain suits can be filed under Specific Relief Act to direct that here. For example, Bombay Stock Exchange rules, वहाँ पे arbitration तो नहीं लगेगा 90 का. These are special arbitration. If the parties are not willing to submit to arbitration under the Bombay Stock Exchange rule or Delhi Stock Exchange rule, a suit for specific performance would lie under section 25. वो जरा खोल लीजिए गौरव, 25 जरा पढ़ लेंगे हम लोग. Application of proceeding, section to certain wards and testamentary direction to execute settlement. Yeah.
Is it the 25 of Specific Relief Act?
Yeah, 25 of this SRA Act.
Okay. 25 of the Specific Relief Act comes under the heading Enforcement of Awards and Directions to Execute Settlements. It says application of preceding sections to certain awards and testamentary directions to execute settlements. The provisions of this chapter as to contracts shall apply to awards to which Arbitration and Conciliation Act 1996 does not apply, and to directions in a will or codicil to execute a particular settlement.
So that means to the Indian Succession Act and Arbitration Act also, Specific Relief Act applies limitedly. Number one, when you see section 3.2, section 3.2 of the Arbitration Act, the 3.2 of the Arbitration Act says, subsection 2 of section 3, this act is not applicable to certain arbitration. For example, Delhi and Bombay Stock Exchange rules, arbitration under the provisions of Electricity Act, wo sab ke liye. If somebody is not performing the part, you can file a suit here in the matter. Otherwise, the Arbitration Act is a comprehensive remedy. You can go under section 9 to the Chief Justice, appoint an arbitrator by giving a notice under section 21 commencement, wo alag baat hai. But the arbitrations under the special legislation, they don't come within the ambit of the 96 Act. Then the provisions of SRA Act will be applicable. You can suit for specific performance of a declaration that the parties be directed to go for arbitration. Then in a codicils and wills, the testator must have given direction to the administrator. The administrator must distribute the will and pay the payment to my heirs and legal representatives, must give in charity. Executor चुप बैठ गया, वो will को probate भी नहीं कर रहा है. So you can file a suit for specific performance. You should be directed to perform his duties. समझे ना? There is no bar. That is the meaning of this section 25. How beautifully it is crafted. Mean to certain specific reliefs only as per the provisions of this act here. So more or less, this is the entire gamut of this section. According to me, we have covered. Anybody want to ask me any question? पूछ लीजिए. There are many judgments which I will not cover, but देखा जाएगा in the main section में देखा जाएगा. किसी को पूछ लीजिए आप.
So let's take a breather for 2 minutes so that everyone can run through whatever we have learned today. And we can come up with the questions, और उसके बाद हम questions लेते हैं.
Yeah.
So anybody who felt this to be too fast to understand or too fast to cling on, this will be slower when we come on to the main course, because it was the complete act to be covered today. So sir, thoda sa tez le gaye hame.
Because
But
you gave me only 1 hour's time.
yeah, so
You had
that was
given
something.
2 hours, देते तो मैं cover कर लेता, slow जाता.
Yeah, so later we are going to be very slow. We're going to take each section, reading each section, reading the judgments and the summaries.
In the later lectures, we'll go step by step, each section with so many judgments, how to draft a plane, how to draft a motion, how to get relief injunctions, सब बताएंगे slowly. We'll point out the provisions of CPC, CRPC, specific relief act को ले लेंगे आप. Now I'm ready for question answers before you all go for dinner, all of you.
All right, guys, you can use the chat for questions. I have 1 or 2 questions right now that I will post to sir that I've received on WhatsApp. So first question that we have got is, can you please tell us the difference between mandatory, perpetual, temporary and interim injunction with examples?
Mandatory injunction, I told you that here. For example, somebody आपके कमरे में घुस गया, please, honorable court, be pleased to direct his removal, isn't it? Forcefully direct him to remove the problem. It's a commandment which is given by the court. Ask him to perform the act directly by completion. Mandatory orders are in the nature of a decree, a final decree, isn't it? It's a final decree, a commandment. It's like a mandamus given by the High Court under Article 226, that you are hereby directed to command to do this particular act. A mandatory act. There is no discretion to evade it. Whereas in the case of perpetual order of injunction, you have been granted a particular act, meaning you have been restrained not to create nuisance lifelong perennially. You have been directed by a perpetual order of injunction not to claim a particular right in this property. Lifelong, it's a decree, because section 37, 38 says that here perpetual orders are in the nature of a decree which are granted here. A final decree. Whereas a interlocutory order, a mandatory order can be granted both at the stage of interlocutory order as well as final order. A temporary order of injunction, order 39, rule 1 and 2, is granted during the interlocutory period, till the suit is pending. After the suit ke baad, they stand vacated. But whereas perpetual order, mandatory order don't vacate. For example, municipal corporation has given a notice to you, that to remove the nuisance. A magistrate under the provisions of section 144 CRPC passing an order, public nuisance be removed. Police officer आके निकालेगा आपको उसके अंदर. Okay, that is the meaning of it. So
yes, answer. What will be perpetual injunction?
Perpetual order injunction is in the nature of a decree. For example, a person may be restrained perpetually not to enter, remain upon in your house. Somebody a trespasser, समझे ना? कोई trespass कर दिया आपके house में, or likely to trespass, that this honorable court could be pleased to restrain him by a perpetual order of injunction not to enter, remain upon.
So
what will
be the difference between mandatory and perpetual?
Mandatory is to do a particular act, demolition act. It can be done at the stage of interlocutory stage, or even the act is performed, the effect gets over. But whereas a perpetual order of injunction, the effect is lasting lifelong. समझे ना आप? So you are constructed illegally a bathroom in your house. Defendant is complaining without it. So the municipality will come and demolish it by a mandatory injunction on the order of the court. समझे ना? Oh, demolish हो गया तो खत्म, injunction is the task is over, completed.
Got it, sir.
Suppose if you are restrained by a perpetual order of injunction not to enter a particular locality, जिंदगी भर आपको नहीं enter नहीं करना पड़ेगा. समझे ना आप? Yes.
Got it. So next one is, what is a codicil and what is a probate?
Probate is a document which requires authentication of a will. A will is not valid unless you obtain a probate from the district court or a high court. In the city of Bombay, district court is a high court. In Delhi, mein district court. Thana, Kalyan, mein district court under the Indian Succession Act. Otherwise, the will has a zero value. Probate to lena hi padega aapko.
So sir, registered will और probate के बीच में क्या difference है?
Registration of a will is not mandatory unless it is for charitable purposes under section 118 of the Succession Act. 118 check करेंगे आप. If it's charitable purposes, registration is mandatory. Hindus will is not compulsory under section 18 of the Registration Act. 18 check कर लो आप Registration Act, उसे मिल जाएगा. It's optional. Section 18 check कर लीजिए. सेक्शन डॉक्यूमेंट्स विच रजिस्ट्रेशन इज ऑप्शनल. इसके अंदर विल भी आ गया, देखिए.
राइट सर.
ओके, ये ऑप्शनल.
एंड व्हाट विल बी अ कोडिसिल?
Codicil is a document which terminates the existing will, a clarification of the new will. It's a codicil is as good as a new will, or it's an amendment of the existing will. Suppose बोलेगा will के अंदर testator, I have given my two sons 2 houses. But codicil में बोलेगा my daughter has been left out, I want my sons to be to take care of my daughter also lifelong, give her the maintenance. So clarification. A clarification which is done in the will is called a codicil. समझे ना आप?
Right. Sir, the querist has asked as an extension to the earlier question कि registered will और probate में difference क्या है? Probate भी तो registration ही है.
Now, probate is a document which is granted by the district court. When it is probated, there is no registration compulsory. See, will itself is not registrarily compulsorable. Once a probate is granted by the district court or a high court, that is a document, a conclusive document under section 41 of the Evidence Act. Section 41, 42 College Evidence Act, 42. It's a conclusive piece of evidence. Section 42 College of Evidence Act. मैं पढ़ के सिखाया हूं आपको मैं. Section 41. Relevancy of certain documents in probate, etc. jurisdiction. A final judgment and order. पढ़िए. 41.
Sir, I'll have to take a minute or two.
Okay, मैं पढ़ूं क्या?
आप पढ़ दो sir.
A final judgment and order or decree of a competent court in the exercise of a probate, matrimonial, admiralty or insolvency jurisdiction, which confers or takes away from any person any legal character, or which declares any person to be entitled to any such character, or to be entitled to any specific thing, not as against any specific person, but absolutely relevant one existence of such legal character, title of such person to such person relevant. Such judgment, order, decree is conclusive proof. क्या? Conclusive proof underline कीजिए. That means you don't require to lead any rebuttable evidence. Court will not disbelieve you. This conclusive proof can only be dislodged under section 44 when there's a fraud take place.
Right.
That fraud. Otherwise, it is conclusive. Ekdam nobody can touch it.
Okay, got it. Sir, another question is, what is the difference between interlocutory and final orders?
Interlocutory order, when a suit is finding, suppose आपने specific performance of a suit file किए, the builder ने आपको flat नहीं दिया. Your first prayer is for declaration that you are entitled to possession. Prayer B, to put you in possession. Prayer C, to convey the document. Prayer D, E, to give you breach profit. That is called final prayers. There are final decrees. Then in between, appointment of a receiver or injunction restraining not to create third party interest, किसी को नहीं बेचने का. These are interlocutory orders. These interlocutory orders will be valid only till the suit is pending. Once the suit is decreed, they will go away. They will merge into the final order. समझे ना आप?
Right, sir.
Ah.
Got it. Another question we have from Gitanjali Sharma. She wants to ask, my question is, in all situations where specific performance does not lie, even for example, matrimonial suits, restitution, example that you gave in the lecture, will the remedy for damages lie?
Yes, 100%. There is always a remedy for damages, both under the provisions of Specific Relief Act and Section 73 of the Indian Contract Act, and under the law of tort also. Under the law of tort. For mental torture, agony, malicious prosecution, tort mein milega na aapko.
Right, sir. So another question is, what is the basic difference between the damages that we can take under 71 and under 72 of the Indian Contract Act? That's out of SRA, but maybe we can take it.
Oh, 73 are the Indian Contract, not 71. Section 73 deals with the damages.
Yeah, so it should be 72 and 73 ke beech ka difference.
73 is a provision under the Indian Contract Act for damages. Section the liability 73 starting with here, compensation for loss or damages caused by breach of contract, Section 73. वो डॉक्ट्रिन भी पढ़ना, रेस इप्सा लोक्यूटर पढ़े ना आपने?
Yeah, 106 of Indian Evidence Act also.
106 of the Evidence Act, special knowledge, where the burden
Special
of
knowledge, yeah. Res ipsa loquitur.
A person, normally the plaintiff has to prove the case, but if the defendant has a special knowledge, he has to, the burden will shift upon him. Suppose, for example, IPC ke andar, the prosecution has to prove the case beyond reasonable doubt. The public prosecutor has to begin the case. Agar a defendant accused says that I was insane at the time of the commission of the offense, or I did the act in a provocation, once because I had a rifle, then that he has to prove specially. That special knowledge is with him. Why he did it? A person traveling without ticket has to prove that he had a ticket. Whether he purchased ticket or not, nobody knows. So he has to lead evidence. Special knowledge is with him. That is right. Yes.
Sir, you said that you can also go under CRPC 144 and 145 if you are dispossessed of your property.
Yeah, 145, 146.
145 and 146. So what is the procedure that one has to follow, and whether the executive magistrate can take a suo motu action, or do we have to apply for the same?
You have to apply. Make an application. Like the application you file under Section 200 CRPC, read by Section 190, Clause A. Make an application. The magistrate will call for the report of the police officer. He will direct the police station to submit report under 145. वो submit report करने के बाद magistrate will pass either order of injunction, or he will put into possession, or he will appoint a court receiver under Section 146 in nobody in possession. 145.
Is this a better remedy or Section 6 of the SRA?
There are parallel remedies. There is no bar. You can approach both. There is no bar. These are in addition to, not in derogation. Like Section 103, Section 100 of the Consumer Protection Act. You can go there. That remedy of the Consumer Protection Act is additional remedy. If that remedy, if the complaint under Consumer Act is dismissed, doesn't mean that you cannot file a civil suit. Similarly, under Section 6, your suit for possession dismissed, you can go for title suit. So there are parallel remedies, but they are not res judicata, unless it is a parallel, unless they fall within the ambit of Section 11 of the Code of Civil Procedure.
Right. So someone has also asked, what is the difference between the concept of set-off and equitable set-off?
Set-off is coming under the provisions of Order 8 of the Code of Civil Procedure. That is under the provisions of the defendant apart from the right to file written statement. Suppose if there are two contracts, a contract, suppose under one contract the plaintiff supplies the goods for 1,000, and another contract defendant supplies good 2,000. So only the plaintiff files a suit for 1,000. Defendant can take up the plea that he has to also pay me in another contract 2,000. So they let the money be adjusted. If they let the money be adjusted, or plaintiff has filed a suit for 1 lakh, whereas under my contract he has to pay me 5,000. Let that 5,000 or 5 lakh, whatever may be adjusted, may be set off. Set off can only take place in respect of a certain amount and not damages. It is not a, it cannot be set off, you cannot set off mean profit, you cannot set off an uncertain amount. That is not equitable to do so by the court. That is how it is done here.
So, sir, what is the difference between normal set off and equitable set off?
A normal set off is under the provisions of Section 8. Then the equitable set off is coming under the Transfer of Property Act. When a mortgage and mortgagee suits are filed here, when you file a suit for a redemption of a suit or a foreclosure of a suit, the accounts are adjusted on equity basis, on the doctrine of justice, equity, and good conscience. In a specific relief act, the suits are based on a doctrine of justice, equity, and good conscience. All the tribunals with the past orders, CPC is not applicable. Justice, equity, and good conscience. So that is a equitable set off. The orders are passed by the tribunals and wherever the forum where the CPC is not applicable. Okay. Yes.
Right. And sir, there is another question. If you can briefly explain what does section 23 of the SRA say? Should I read it?
Yeah.
Liquidation of damages not a bar to specific performance. A contract otherwise proper to be specifically enforced may be so enforced through a sum be named in it as amount to be paid in case of its breach, and the party in default is willing to pay the same, if court, having regard to the terms of the contract and other attending circumstances, is satisfied that the sum was named only for the purpose of securing performance of the contract and not for the purpose of giving to the party in default an option of paying money in lieu of specific performance.
Yeah. It's like you not only go for damages, you can go for also specific. When dual remedy is provided here. Isn't it? Dual remedy is provided. When you want to claim damages, also go for specific performance. Suppose, for example, under the contract, I agree to build some room or library for you, which I have not done it here. You may say that here the defendant, the plaintiff may be agreed by the fact that the delay has taken place and I committed breaches. He may go for damages under section 73 as well as specific relief act. At the same time, he may say that I must honor my promise of building the library under the contract, and I must be specifically directed to perform the contract, namely build it here. Alternate remedies you can ask, there is no remedy. Alternate prayers can be sought for in the matter, there is no bar. Even section 24 said that section 23 doesn't bar the specific performance as well as damages. Unlike the provisions of order 2 of the CPC, which says that all reliefs which are available to you must be taken together. And if you relinquish one of the remedy and you cannot, without the leave of the court, file a separate suit. That is the remedy here. So that means you can sue for damages, you can sue for specific performance.
Understood, sir. So unless we have any more questions, we will wrap up the session here. Is there any more question? You can use your raise hand feature or the chat or anything else. In the meantime, I'll share the link once again and my phone number as well, so that you can go for the course if you would like.
Or any more question from anybody?
Sir, I think not. So if anyone has any question that you want to ask, you may mail it to me. Sir, Mr. Ahuja wants to ask if you can give some information on res judicata.
Yeah. Section 11 CPC, res judicata, there must be a suit must have been finally disposed of by recording evidence after framing of the issues. The second suit on the same cause of action between the same parties or their representatives is barred. Same cause of action, same suit. If it's a different suit at different remedies, res judicata won't apply. The cause of action must be same. Like under section 300 CRPC, the person cannot be convicted twice, isn't it, for the same offense? Doctrine of what it is doctrine called? What is the doctrine? That is also under Article 20 of the Constitution of India.
Auto fois acquit and auto
Or
fois.
same thing. You cannot be prosecuted twice for the same offense. You cannot be convicted twice.
Auto fois convict, auto fois acquit.
Yeah, that is a section 11. That is the same scope under section 11.
Yeah, that's dual jeopardy also.
Yeah, doctrine of double jeopardy.
Yeah, and sir, Mr. Ahuja also wants to ask, what is constructive res judicata?
वो order 11 के अंदर explanation दिया गया है. Suppose in a constructive res judicata, court not having jurisdiction can still give a finding with regard to certain subject matter. That finding is also constructive res judicata. Like City Civil Court, Bombay, or District Court does not have a right to try suit under the rent control legislation. But a passing observation, a question, incidental question may come. The suit is filed for mandatory injunction, specific performance. But relationship of landlord and tenant may come into play. The court may say that a lease has been created. The court may say that the lease is fictitious. So it becomes constructive res judicata if it is not challenged. Okay. And they find even provisions of order 21, rule 103 के अंदर check करेंगे आप. A limited court of jurisdiction giving a finding is a constructive res judicata.
Got it, sir. All right, guys. Any more question? I think this is where we wrap up. We have already struck 10 now. It's 10:15 already, and we've taken a lot of time from sir. It was 1 hour was stipulated for us. We've taken 2. All right, sir. I think we are done with the questions.
Okay.
Raghav,
you have beautifully moderated and done a great job. I'm so happy to be associated with you.
It's totally our pleasure and mutual feeling. I think it was fun. The lecture was a lot of fun and a lot of information. Actually, बीच में कुछ थोड़ी सी ज़्यादा information हो गई थी, तो it might have taken a toll on some people.
It's a legal entertainment.
Yeah, legal entertainment, right? Yeah, and we hope we'll see all of you on 7th when we start with the sessions, and we're going to take it in great length and depth. And SRA में फिर आपको कोई issues नहीं होंगे. And I'll part with a note of gratitude for sir for joining us for such a long time, and all the participants who have joined us today evening. Have a good night, everyone.
Okay, bye bye. Good night to all of you. To Gaurav too. Okay, thank you, dear.